Welcome to this civics lesson on the history of property rights as a civil liberty in Canada. Property rights in Canada stem from an over 800-year-old constitutional tradition. They were developed through English constitutional law and incorporated into Canada's constitutional structure via the Preamble to the Constitution Act, 1867. Canadian courts have repeatedly confirmed these rights. There are three key foundations for these rights. They are the constitutional principles incorporated through the Preamble to the Constitution Act, 1867, the historical development of civil liberties starting with Magna Carta, and the modern constitutional framework, including case law, the Canadian Bill of Rights, and Section 35 Indigenous land rights. Civil liberties, including property rights, entered the Constitution through the Preamble to the Constitution Act, 1867. The Preamble states that Canada is to have a constitution similar in principle to that of the United Kingdom, importing constitutional traditions into Canadian law. The full text is available at the link provided. British constitutional principles imported into Canadian law include the rule of law, limits on executive power, judicial independence, parliamentary democracy, and historic civil liberties recognized at common law. Civil liberties protected at common law include the protection of property, the protection of lawful possession, the security of the home, and protection from arbitrary government interference. Canadian courts confirm the Preamble as a source of these constitutional principles. In the 1997 decision, reference Remuneration of Judges, the Supreme Court confirmed that the Preamble incorporates foundational constitutional principles and identifies the organizing principles of the Constitution. The full decision can be accessed via the link shown. In the 1998 case, reference Re-Secession of Quebec, the Supreme Court reaffirmed that the Constitution is more than a written text. It includes a global system of rules and principles governing constitutional authority, derived from the Preamble. The decision link is provided for reference. Many Canadians assume the Charter of Rights and Freedoms protects property rights, but it does not. Property protections were explicitly removed during the 1982 constitutional negotiations. The Charter does not explicitly protect ownership or enjoyment of property, nor does it guarantee protection against uncompensated takings. Furthermore, search and seizure protections in the Charter are subject to limitation clauses, which can restrict the right. The real legal protection for property rights at the federal level comes from two sources. These are the common law and the Canadian Bill of Rights, which provide the strongest explicit legal recognition. As a civics lesson, property rights exist in Canada's legal tradition and are protected by the Constitution. They are part of the civil liberties tradition of common law, explicitly preserved in the Canadian Bill of Rights and developed over 800 years since Magna Carta. All levels of government are bound by the constitutional civil liberties and the rule of law. This includes the federal parliament, provincial legislatures, municipal governments, and administrative bodies and tribunals. Provinces have jurisdiction over property and civil rights, but this authority is not unlimited. Provincial laws must operate within Canada's constitutional framework and cannot undermine fundamental civil liberties. Municipal governments are created by provincial legislation and are creatures of statute. They only possess the powers granted by those provincial statutes. Bylaws must comply with enabling legislation, constitutional principles, and civil liberties. The Alberta Press Reference case in 1938 saw the Supreme Court strike down provincial legislation that attempted to control newspapers. The court affirmed that civil liberties essential to the constitutional system cannot be suppressed. In Saumur v. City of Quebec, 1953, the Supreme Court ruled that provincial and municipal laws cannot suppress fundamental freedoms. This followed a municipal bylaw restricting the distribution of religious literature. The Switzman v. Elbling case of 1957 involved the Quebec Padlock Act, which allowed the closure of buildings suspected of communist activity. The Supreme Court struck down the law, confirming freedom of expression as a fundamental civil liberty. The 1946 case of Campbell Motors Limited v. Gordon established that statutes must be interpreted consistently with fundamental rights, reinforcing the importance of civil liberties in interpreting law. Roncarelli v. Duplessis, 1959, involved the arbitrary cancellation of a liquor license by the Quebec Premier. The Supreme Court ruled it an abuse of power, with Justice Rand stating there is no such thing as absolute and untrammeled discretion. Looking back, the Magna Carta of 1215 is the origin of property rights and due process. Clause 39 ensures no person is deprived of property except through lawful judgment. The Petition of Right in 1628 further limited the power of the Crown and protected property from unlawful seizure, strengthening early civil liberties. Entick v. Carrington, 1765, established the protection of private property against arbitrary government action after the court ruled a government search and seizure of papers without authority was unlawful. In Canada, property rights are rooted in the British common law tradition. These rights are protected through constitutional principles, common law, statutory law, and the Canadian Bill of Rights. The Canadian Bill of Rights, Section 1, recognizes the right to life, liberty, security of the person, and the enjoyment of property, providing explicit statutory protection at the federal level. Property rights in Canada apply not only to landowners, but also to lawful occupiers, tenants, leaseholders, and licensees. Tenants, for example, possess exclusive possession protected by law. Squatters' rights, or adverse possession, allow long-term occupants to obtain legal rights to land under specific conditions. These typically include actual, open, exclusive, and continuous possession without the owner's permission. Note that the Ontario Land Titles Act restricts this doctrine. Section 35 of the Constitution Act, 1982, recognizes and affirms existing Aboriginal and treaty rights of the Indigenous peoples of Canada, which are paramount. Key Indigenous rights cases include R v. Sparrow, which established the Sparrow test for justifying infringements, Delgamuukw v. British Columbia on Aboriginal title, and Tsilhqot'in Nation v. British Columbia, which clarified how to prove Aboriginal title. This timeline illustrates the progression of civil liberties and property rights from the Magna Carta in 1215 through various legal precedents, culminating in the Canadian Bill of Rights and the recognition of Indigenous rights under Section 35. The Trial Lawyers Association v. British Columbia case in 2014 affirmed that access to courts is protected by the constitutional principle of the rule of law. Governments cannot impose barriers preventing citizens from accessing justice. The decision link is provided for reference. In conclusion, property rights in Canada arise from an over 800-year constitutional tradition. These rights were incorporated into our system through the preamble to the Constitution Act and confirmed by court decisions. Property rights remain a pillar supporting liberty, security, and the rule of law in Canada. This video's content relies on a number of key legal authorities. These include significant Supreme Court of Canada cases that have shaped the interpretation and application of property rights and civil liberties in Canadian law.